Good afternoon, everyone. Thanks for joining this webinar. My name is Alice Humut. I am a consultant at Löning, and I have the pleasure of being your moderator today for this Ask the Experts live Q&A session edition on shifting the perspective towards worker-centric human rights due diligence with a focus on grievance mechanisms. A quick introduction to those of you who may not know us. Löning is a management consultancy based in Berlin with an exclusive focus on human rights. And this means that we advise companies on all aspects and elements of human rights due diligence, including, of course, the implementation of effective grievance mechanisms. And generally, we advise companies of different sizes, different sectors, different levels of maturity when it comes to implementing human rights due diligence. And I am very happy to have with me today our two experts and panelists. We have Löning's Marianne, who is an expert in human rights and alternative dispute resolution methodologies before joining Löning for the German Chancellor Fellowship, funded by the Alexander von Humboldt Stiftung. Marianne worked in Brazil as an alternative dispute resolution professional in a company-based remediation program with international repercussions. And here at Löning, she focuses on establishing and improving grievance and redress mechanisms for human rights adverse impacts along value chains and together with our clients. And we are very happy to be joined also for this session by Thomas, who is the Europe representative of Ulula. Thomas is a responsible supply chain expert. He lived in Bangladesh and China for 7 years, where he visited more than 250 factories. He worked on developing concrete actions to improve working conditions and traceability for a large French retailer, and he is also currently based in France. Hello, both of you, and thank you for joining us today at this Ask the Experts webinar session. A few words maybe on Ulula, for those of you who also don't know Ulula or don't know them yet. Ulula is a mobile-based direct worker survey and grievance management technology company. And it has quite a large coverage, larger than most of its competitors, with established effective worker engagement programs across more than 50 countries and more than 80 languages, including the amphoric grievance mechanism called Speak for Change. And we have actually partnered up with Ulula in the past also, and hope to do so also in the future to implement joint projects. I think a past one was on a worker voice survey that we implemented for a client in Myanmar. So do reach out if you're interested what we're offering together. But before we jump into the content side of this event today, it is my role as a moderator, of course, to remind us of a few things. First of all, we plan our Ask the Experts webinars in such a way that our two experts give us an initial overview of the topic, and then we quickly open the conversation to your audience questions, which you're very welcome to ask via the question function, the Q&A function in Zoom. And there's also a chat function, which you have maybe already seen, where my colleague has posted some interesting follow-up leads and links for you. But please, for the questions, do use the Q&A function. And there's also the possibility to prioritize the questions that are already in the Q&A slot by upvoting the ones that have already been asked. And this allows us to see which questions are particularly relevant for you as an audience. So do please make use of that function. If any questions may remain unanswered, we will send them to you afterwards with answers, of course. And there will also be a recording of the webinar, so feel free to share that with your colleagues afterwards. We will also share a short and quick post-webinar survey with you to be able to improve this format further. So it'd be amazing if you could take a few seconds to answer that at the very end of the webinar. And last but not least, a short disclaimer. We do not give any legal advice. We interpret the text of the law with our expertise and our experience, and we talk about it a lot, but we do not give any specific legal advice. Okay, so that's that. And now let's look at the actual topic of today's session, shifting the focus toward more worker-centric due diligence efforts, especially in the field of grievance mechanisms. Now, why does the focus need to shift, you may ask? And we see, or from what we see in our daily work, is that especially now with the development of more mandatory human rights due diligence, many companies stick to the minimum interpretation of the human rights due diligence elements and lose sight a little bit of the overall aim of the exercise, namely the impact on people and workers in the most cases. And I find this is especially true for grievance mechanisms. Maybe a quick reminder here that grievance mechanisms allow for everyone who's aware or affected by an adverse impact of a company's operations to raise this to the company, who then has to stop or at least minimize and remedy the situation. And grievance mechanisms are quite an important or very important in safeguarding the interest of potentially affected people, as in the classic risk management process that you see here as a continuous process of risk identification and mitigation. No perfect system exists. So no company will be able to identify and stop all of its adverse impacts in this classic risk analysis and mitigation process, or at least not all at once. So this is why this additional step of the grievance mechanism is so important. And also within the context of the Lieferkettengesetz, the German Supply Chain Due Diligence Act, the legislator has clarified in their FAQs that grievance mechanisms, together with the definition of responsibilities, are the two core elements that have to be set up from the beginning. So make sure you have those in place. I hear that BAFA, so the assessing authority and implementing authority, is starting their series of assessments and is sending out letters. So do reach out if you have received such a letter and need support. But before I start asking our panelists the first questions, we have a question for you as the audience and the affected companies. The answers to this poll are anonymous, so please do take a few seconds and answer the poll that my colleague is about to share. And here you will see that the question we ask is, at what stage of implementing human rights-oriented grievance mechanisms you are right now? Have you already implemented such a grievance mechanism for human rights? Are you starting to implement one? Do you have another channel, such as a whistleblowing channel, but no specific human rights channel? Have you not started yet at all? Or are you not planning on starting at all because you don't fall under the law, or you are not placed in Germany, for example? So that would be really interesting for us to hear what your situation is, and we will then share also with you our results. So let's give you another few seconds to read through the questions and maybe give us an answer. The last ones are coming in. Okay, we stopped. So now we will share the results with you. And we see here definitely that most of you have started or have already a functioning grievance mechanism for human rights, which is great. A lot of you have also already started implementing one, have an alternative channel, but not a human rights specific one. But some of you also are not planning to set up a grievance mechanism because it's not applicable to your company, maybe. Okay, thanks a lot for sharing. And that actually is quite an interesting insight. I would have expected less people to be so advanced or less people in the audience to be so advanced. But so we see that some of you already have some experience. And Mariana, does this coincide with what you are seeing also in practice from our work with clients and also in your general experience?
Yeah, hello, Alice. Thank you for setting the scene. Good afternoon to everybody. Thank you for taking the time to joining us today. And yes, Alice, actually, from our experience, what we have been seeing is that companies are basically mostly organizing themselves in two ways. One of them is establishing new human rights due diligence specific mechanisms. So usually a different dedicated channel, sometimes even independent outside of the company's own structure, with a specific responsible team, sometimes the CSR team, and nowadays more and more frequently under a human rights officer. Another tendency, which is also very common, that's something that we have been seeing in our practice here, is that the tendency to use channels that are already in place, right? Try to adapt existing, usually ethics and compliance-based complaints platforms, focus on code of conduct violations, in most cases led by the legal teams, or more compliance-based approach. And some challenges also that we see then in the second approach is the fact that the human rights oriented grievance mechanisms, they are intended to cater to a different audience, so they have a different perspective. And that's because the center point of the risk analysis, when you're talking about human rights due diligence, is outside looking and not inside, not for the company. The LKSG and the German Due Diligence Act requires, for example, that the channels are accessible for all those possibly affected by adverse impacts. So they must enable the reporting of human rights and environmental risks and violations from the their own business area all the way up to indirect suppliers. From that unfolds that internal channels, strictly internal channels, for example, an intranet, it's not sufficient. And that also entails the need for heightened to address accessibility. So such as offering the different languages, adequate working hours, or even 24/7 accessibility, and very importantly, communicating the mechanism to the rights holders. And to achieve this accessibility, engagement with stakeholders, a worker-centric approach here during the design, the operation, and the evaluation of the efficacy of the grievance mechanism is crucial. So what we also see is that those that do not do this engagement, that do not understand their audience from the beginning on, they end up spending more as the mechanism is put in motion, and then the shortfalls of a one-size-fits-all approach make evident that this mechanism is not trusted, that's not being used, it's inappropriate, it's ineffective, and that leads to rework, to adaptations of internal proceedings, introduction of new channels, and some can lead then to double work.
Thanks, Mariana. Yeah, that's a good summary. So I understand that companies are on their way, but there's still a lot to do, right? Thomas, what is your impression?
Yeah, thanks, Alice. Good afternoon, everyone. And thanks for the question. I can share my perspective, which is based on the conversation we have with our clients or with companies reaching out to Ulula. And companies are actively working on, so basically the legislation has impacted supply chain grievance mechanism on three major components compared to what companies were doing before. I think the first impact is related to the effectiveness, and we see a clear mindset shift where receiving zero grievances from the channels in place is not a good thing anymore. This is no longer seen as, okay, everything is all right, but it says something about the lack of effectiveness. So traditional hotlines, web page, etc., are found quite ineffective if they aren't designed adopting the worker perspective. I think the second impact is related to reporting and required access to data, like number of grievances, typology of grievances, etc., which means it is not sufficient anymore to just verify if our vendors, they have a system in place. Those systems must be digitized to enable the data collection at scale. And the third impact is related to the scale of what is required to implement. And an effective grievance management system is as good as its scalability. And companies, I think, are currently mapping the existing systems established in their supply chains to see what they can leverage. And I can share eventually two examples. The first example is companies looking at their most strategic vendors and what grievance management systems they have established, if any. And our clients are working on, one, eventually challenging their effectiveness, and two, evaluating how they can access the data. I can share a quick story here. We have a case in Tanzania where one of our clients reached out to us because their vendors, they had grievance management systems in place, but they could not provide access to any record or access to any data because they had a very traditional approach with local phone numbers accessible, and workers could use them to reach out to dedicated people in the HR team. But the challenge for the brands was, I mean, they had concerns about, is the system protecting the anonymity, how they can access the record? There is no performance analytics. So they asked Ulula to equip these vendors with our platform, so the calls get redirected to our platform and then made accessible to the HR team via a dedicated module. So the platform protects the anonymity of the complainant and produce real-time performance indicators. So this was an example of how companies are looking at vendors' existing system. The second example is companies are mapping the established grievance management systems established by multi-stakeholder initiatives or auditing standards. And here, an example is Amphori Speak for Change program, where Lula is the tech provider, and where by the end of 2023, all the Amphori vendors will be covered in 5 countries, which are Vietnam, Turkey, Bangladesh, India, and Cambodia. We can eventually speak more during the Q&A session. So there are a number of systems already in place, but a very important point, in the supply chain, not all the systems are equally effective and accessible as required by the law. So companies should carefully assess these components.
Okay, thanks, Thomas. So we just heard about some concepts that are keeping companies busy, effectiveness, accessibility, and so on. And the UNGPs, but also the new human rights due diligence laws require that these grievance mechanisms are appropriate and effective. But what does that mean exactly? Mariana, could you maybe give us some concrete examples of what effective and ineffective can mean in different contexts?
Yes, Alice, and thanks for the question. Yeah, indeed, effectiveness, it's so important. It has its own dedicated principle in the UNGPs, this principle, the 31st principle. And as you can see here in this slide, these are components that together work to make a determined grievance mechanism effective, right? So for our topic today, when you think about worker-centric grievance mechanism, worker-centric due diligence, I'd like to highlight some of these components. So grievance mechanism, it has to be legitimate, which means it must be trusted by users, but it also has to be accessible, which means being known, but also low threshold. So there have to be low barriers to actually be able to access this mechanism. They also have to be transparent, so all the parts, the involved parts, should be informed on the steps of the procedure as it moves forward. And of course, rights compatible. So they must take in consideration, they must work in accord with internationally recognized human rights. So as an example here, when you take rights holder worker-centric focus, that requires adequation not only of the language, that are certain channels available, let's say in English, Portuguese, German, anyways, but also of the wording, or even the use of symbols or pictures, whatever is necessary to cater to the affected public. So they actually have their rights upheld, right? This kind of measures, this kind of accessibility, that brings people to trust and to use the mechanism. So it actually works as an early warning system, and that means that it's effective both for rights holders and for companies alike. The LKSG on its side, for example, works with the concept of appropriateness, right? Which, as stated in the BAFA's guidelines, is closely connected with effectiveness, because measures can only be understood to be appropriate if they are chosen from a selection of effective instruments. Here at Löning, we have also recently published a post about appropriateness. I'm going to ask the link to be put here in the chat so you have access to it. And you can also understand a bit more of the concept of this topic. And reach to us if you have any other questions on that.
Great. So appropriateness we've learned and effectiveness such as accessibility are crucial. And maybe Thomas, what are the common misconceptions you've dealt with when working with companies in establishing grievance mechanisms? Are there steps that are being overlooked that could improve in the effectiveness of these mechanisms?
Yeah, I think it will also connect with what Mariana just mentioned, but while adopting a worker-centric grievance management system, can shortlist 3 important considerations being frequently overlooked. The first one is, again, the accessibility, and the higher the barriers to access the reporting lines, the more vulnerable workers get excluded from the system. So as you can see on this slide, there is a table that shows how variable is the smartphone coverage across the apparel major sourcing countries, which is as low as 30% in Bangladesh, for example. So, for example, app-based solution in most of these countries will exclude workers without a smartphone, for example. And we also see that very clearly in our data comparison. A second point, which is a second consideration overlooked, is the effective promotion of the reporting lines and trust building. An effective grievance management system is not just about the tech, it is also about how we socialize the workers with it. So how the targeted workers will know about and trust the reporting channels. Another example I see very often, great list of local phone numbers, but they are accessible only on company's webpage in English. So how the workers are supposed to find and trust them. And a third point of third consideration frequently overlooked is that there is no one approach that fits all for all type of industries, all type of regions. So I can show on the next slide, I can share basically the Ulula framework to define the worker-centric grievance management system adapted to industry-specific and country-specific contexts. So the first point is about adapting the grievance typology. So your scope is also locally relevant. The second point is about adapting the reporting lines, which should be free, in multi-language and accessible via multiple channels. Okay, one example I can share is with Amphori. We are proposing workers to log a grievance via the local chat app in Vietnam called Zalo, which is one of the possible channels. And unlike WhatsApp, this channel is widely used by workers on a daily basis and trusted. The third component is about adapting workers' onboarding strategy to industry and country context to create legitimacy. So we do not adopt the same strategy to onboard workers like crew workers on a fishing vessel in Thailand, cocoa producers in Côte d'Ivoire, home workers in Nepal, or temporary workers in South Spain. We have to adapt the strategy. The following 2 criteria are really helping us to validate that the system is effectively worker-centric. So the first one that you see is about the onboarding validation. So we encourage our targeted audience to participate in a short baseline survey during or after the onboarding, and the response rate is an important performance indicator to validate the effectiveness of the onboarding. And lastly, after every case resolution, this is our golden KPI, the system sends automatically a very short satisfaction survey to the complainant who raised the grievance, and this really helps us to track the overall system performance, adopting the local perspective. These are eventually some of the things I can share, Alicia.
Yeah, thanks. Yeah, that's really interesting. So there are quite a few challenges I'm anticipating for companies, because this I mean, of course, entails a lot of work. And we've prepared a second small poll. Again, it's anonymous, where we ask which challenges you as a company are facing when implementing a grievance mechanism for human rights. Is it the accessibility that we've spoken so much about? Is it that the workers are just not using it? Is it very complicated because of the many languages? Is there a lack of internal capacity to handle the cases? Is it very expensive just because you are active in so many different countries and supply chains? Is it the problem that you don't know which software to use? I mean, we have Ulula here on the call, but there's of course also others. So yeah, do let us know. And I again see that we have some participation here, and it's quite interesting to see. And I'll give you a few more seconds to choose your answers, because they're always, of course, quite interesting for us, but then also for you as an audience to see what your peers maybe are doing. So the more answers we get, the better for everyone. Okay, so I think 2 more seconds and then we can close. And okay, so what we see is basically the challenge that we also anticipated, and this is why we spoke so much about accessibility, is that exactly the workers in the supply chain don't have access to, or not enough access to these channels. We also see, of course, the issue that it's not being used, and I think this is definitely also linked to the accessibility. Or to the trust that we haven't touched upon as much today. And of course, the software solution. And yeah, so language-wise, it's also an issue. Okay, so thanks a lot for sharing. And coming back now to the very last question, and I see we've gone slightly over time already, so let's make this a quick one, but I think this is definitely also quite relevant for a lot of the members in the audience. So I do want to quickly touch upon it, is that talking about all of these challenges, also the question comes up, and we've been asked that a lot, how far does the company's responsibility really go in terms of grievance mechanisms and also addressing these grievances? Mariana, can you quickly give us your take on this?
Absolutely, Alicia, I'll do my best. As it states here in the slide, in terms of responsibility, the international best practice is based on the UNGP's triad of causation, contribution, and linkage. So it takes in consideration a whole ecosystem and how different actors engage and interact in order to reach or in a determined violation or adverse impact. So when you talk about responsibilization, about responsibility, and you think about the KSG, the German Act, the law also determines that in a grievance mechanism, companies must be able to receive complaints from the value chain, right? From own business areas all the way to indirect suppliers. And what I think it's important to have in mind here is that once a complaint is received, it must be dealt with, and that must be documented, which does not necessarily mean that will become a case or that will lead to remediation. You can reach a no-case decision, for example, if it does not pertain your company, your activities. The important part here is being transparent to the person who brought the complaint about what happened, why will not move forward, eventually other channels that could be reached. And so keep this communication, and also think this on procedural justice, right? To think on transparency on the process. And on a final note, just remembering, coming back again to appropriateness, that can be a real ally here in prioritizing when dealing with grievances. Because it applies, the concept of appropriateness applies from grievance handling and remediation also. And so it offers room for prioritization as long as there is a firm standing documented rationality for all the choices that a company is making when it's dealing with these complaints.
Great, thanks. That was quick enough, hopefully. There's quite a few questions that have come in, and there's a question that kind of links back to what you just said, Mariana, so I'd like to pose it to you straight away. And just a reminder to everyone that you can pose more questions if you like to our panelists, and I'll distribute them in the Q&A function. So a question here was more related to the cost. So what the cost of a grievance management and follow-up is until a resolution has been found. And of course, that probably depends, but I'll still pose it to you, Mariana.
Yeah, that's a tricky question because, of course, it will depend on the company and especially on the subject. For example, once you receive a complaint, you do the initial investigation, understand that there is suspicion that could actually be a violation or indirect impact. It will also depend on the topic. For example, if it's a situation that involves child labor or forced labor, you might need to engage with specialized remediation providers because it's a very tricky subject and you need to be really aware of the context. So it really is very difficult to understand how much one complaint would cost. I would like to keep in mind that it's important to have a standard procedure, but that the different aspects of the company's activity and of the complaint that comes in are gonna make a lot of difference in that, the cost related.
Yeah, I agree. I don't know, Toma, if you want to add something on the specific point. Otherwise, I'd have two more questions that relate to Ulula.
Yeah, I mean, thanks for the question. Well, as Mariana said, it can vary. What I can mention is maybe our costing structure is made of annual licenses. So basically it depends on number of sites, number of countries that we want to involve. And there is kind of an annual recurring license that enables the sites and the workers to access the platform, to centralize the data, etc. So this is more for collecting the grievances, accessing the data. Then the effective resolution itself is indeed on a case by case. It depends if you have to send someone for investigation, if you need in-depth capacity building, etc.
Yeah. Okay, thanks. Then let me maybe pose two questions to you, Toma. So the first question is if Ulula offers a grievance mechanism that manages the entire grievance reporting, management, response, and solution cycle, or just the reporting phase. And you've just touched upon it, but maybe you can elaborate a little bit on what, like in this whole cycle, what you actually offer and where you maybe work together with others.
Yes, thanks for the question. So we are a tech provider. So we are providing the technology and we'll adapt the tools, the channels, as we discussed today, to make sure that the system is adapted to different supply chain, different countries. So it's really about setting up the channels for receiving the grievances, and not just one channel, but a broad range of possible channels. It's about centralizing the grievances into one case management module. And we provide also different features to enable case handlers to be able to respond to the complainant, create tasks, upload evidence, etc. In order, so it's basically a case management platform. We also offer the reporting, so the dashboard that produce real-time performance indicators. On the top of that, if and when required, we also provide case management support. So basically facilitating the triaging of the cases coming in the platform. And we also offer kind of an overall program support. We partner with organizations for example, the initial program setup to align eventually with company strategy, develop procedures. This is how also we work, for example, with Löning to provide this like advanced consultancy service. And we have also a broad range of partners that will support more advanced remediation support, such as digital trainings, capacity buildings, etc. I hope I answered, but it is not just about the tech. We are providing and supporting the very comprehensive grievance management system.
Mm-hmm. Thank you. And the second question that addresses Ulula is how Ulula worked together with rights holders when developing their tools and solutions, and probably also is continuing to improve their system? Because I know that you're also improving, always trying to improve the system.
Yeah, thank you, Paola, for the great question. I can share a couple of examples. So we are a team of 45 people. We have lots of people in Canada, in Europe, but also locally in different countries. However, one component which is really designing the tool and the channel, so it's worker-centric. We have basically two major approaches. The first one is performing focus groups with our targeted audience. So this is what we've done, for example, with Better Cotton Initiative in India, where we wanted to design a system centered accessible for the farmer communities in very remote places. So we performed a couple of focus groups where we have invited workers, but also worker representatives to answer questions about how they are utilizing the mobile phone. Do they trust when we say it's anonymous? Do they trust it? What does it mean for them? What are the typology of grievances that are meaningful for them, etc. So we really validate a number of things and how we should promote the tool among the wider communities. We have performed, for example, similar activity in the construction sector in the Gulf countries, where we were setting up a system as well. This is really the first approach. And besides that, we can also consult with ground-rooted organizations that will help also share feedback and experience. This is what we've done also with Amfori. For example, we were asking local partners if workers, they have a smartphone, but also if it's not just about having a smartphone, are they comfortable scanning a QR code, for example? So we have these two approaches. One is focus group directly with worker representatives and consultation with ground-rooted organizations.
Thanks. Yeah, I think that's quite an extensive answer. Thanks. Maybe a question for you, Mariana, about the responsibility of companies concerning the linkage. We have a question about the topic of remedy, which is quite interesting. And I know we spoke about it also before the session, in preparation for the session, the whole topic of remediation under the UNGPs, but then also under the German law, and that there is quite a significant difference. So maybe you can elaborate on that.
Yeah, and you understood correctly. I just read the question here. Yeah, in the linkage, there is no expectations that companies will remediate, which of course should not refrain them from doing so. If in a determined situation, they can help, they can contribute. For, as I said, the ideas of an ecosystem of actors that interact with one another. In some situations, you might have a company that, or even a financial institution, which would be linked to the adverse impact, but better suited to offer remediation. So in these cases, of course, they are stimulated to do so, but according to the international best practice, when you think the OECD's responsible business practices, when you think the UNGPs, really is in linkage, there is no direct obligation to remedy. It's from causation and contribution in the matter, in as long as far as the contribution of the company goes into the actual violation that ensured. Is there anything else?
Well, I think that was accurate, and I just also want to add that also under the German law and under most frameworks, there's an obligation to remedy, and also in the German law, it's not really even a proper obligation. However, it's seen favorable for the company when the BAFA, the authority, checks what the company has been doing, and if the company can show that they've also undertaken efforts to remediate or to remedy the situation, then that's definitely favorable for the company, although there is no formal obligation for remedy in the sense of Wiedergutmachung, which is a difference to just Abhilfe, if I may use the German terms. So I hope that helped. We have time for, sorry.
Can I just add to that?
Sure.
Because you're thinking here of remedial action, right? And the own German law also establishes the difference. If it's your own business area in Germany, you have the obligation, you have to stop the violation, but the further away you go along the supply chain, the expectations are different, right? And then I guess compensation and remedial action, they are separated in the interpretation of the remedial actions, of the remediation in the German law. Yeah.
Yeah. There's two more questions concerning the requirements of a compliance officer, which qualifications they should have. Probably the question is, I can just say that of course there should be some requirements. And Mariana, maybe you can also speak from your own experience, because you have done the job of, I guess, compliance officer here is meant in the sense of somebody handling also the cases of a grievance mechanism and being involved in the grievance mechanism. What do you think would be helpful for such a compliance officer dealing with grievances? What it would be helpful for them?
Yeah, thanks, Alicia. My experience is as a case handler, of course, not a compliance officer in the sense generally attributed to it. And two things that I have found interesting actually from my background, which is knowledge of alternative dispute resolution, because it allows us to understand how a dialogue-based approach can be reached, which is very important when you're thinking about business internally or internal grievance mechanisms. I think it's important to point out that also the internal grievance mechanism from a company, it's a part of a whole system to achieve remediation for human rights adverse impacts. So you have the judiciary, you have state-based, non-judicial mechanisms, and then you have the company-based. So in that sense, it's important to be dialogical. So a first thing for a complaints handler would be to be able to understand the demands and craft the solutions accordingly to the demands of the situation and the demands of the rights holders. Thanks.
Thomas, you also wanted to add something in this regard?
Yeah, I very much agree with what Mariana said. I think the case handler or company officers are not in charge of addressing all the grievances that might come up. They are probably in charge of coordinating, finding the right person to be able to respond to this specific concern. So we see that clearly when we have a case coming about sexual harassment in palm oil plantation or child labor in cocoa, you need to be able to, you cannot address everything by yourself. So it's very much about the teamwork, adopting, and if the question was from a brand perspective, I think it's very important for this officer not to work in silo, because one of the most one of the key components is also the engagement of the suppliers to make sure that they are also responsive, they are taking this very seriously. So engaging the commercial team, engaging whoever owns the relation with the supplier will be very much key. So someone also locally present with clear connection with the team in charge of the supplier management is very crucial too.
Great, thanks. So we're at the end. There's one more question that I'll just quickly try to answer. It's a very complicated question. And of course, what we've seen is that there's a proliferation of factory-based grievance mechanism, and every brand has their own grievance mechanism. And I think we see now some developments in the different sectors where companies try to come together, for example, with the Amphori solution where Ulula is supporting also at the moment, where it's really tried to find a solution that will span over more than just one factory. And I think at the moment we see that this is happening more on a sector basis, and multi-stakeholder initiatives are taking the lead there, but also other associations and so on. So I think that's definitely something we will see in the future, that there will be a convergence of mechanisms. But let me try to summarize some of what we've said in the past 45 minutes. So grievance mechanisms obviously need to be effective and can only be so if rights holders are at the center of its design. This can, of course, be supported by technology and preventative measures, and then remedy should always be also part of the grievance mechanism discussion. So If you now leave the webinar, there will be a post-webinar survey that pops up, which I mentioned earlier. Any unanswered question, there is none, so we won't share any specific answers. However, the recording will be shared with you. Do reach out if you have any more questions, and please subscribe to the Löning monthly briefing for monthly updates and newest developments that's been shared also in the chat, and also to the Ulula newsletter if you like. Thank you very much for listening. Thanks a lot to my panelists. And it was a pleasure doing this webinar again, and hope to see you at the next one that we will hold soon, hopefully. Good afternoon.
Thank you.
Bye. Thanks, everyone.
Thank you.